Good afternoon, everyone. My name is Lluc Cerda. I'm a Senior Managing Associate here at the Calgary office of Samfiru, Tumarkin. Thanks for joining us today. We'll be taking your employment law questions. Feel free to put a question in the chat. I'll read it out and I'll be answering your questions live. So feel free to reach out as soon as you have a question. We oftentimes get quite a few, so if you want yours to be answered, better to put it in early. One thing I wanted to start off by talking about today, I get this from almost all of my clients. They get terminated, they get a termination letter, and they're in a panic because the termination letter says, here's a severance package for you to review. You have a week to accept it. So now you're scrambling, trying to figure out if your severance package is fair, trying to figure out if you can get a lawyer to review it, and trying to decide after having reviewed with the lawyer whether you're going to take the severance package or not. I want to dispel the myth that this 1 week deadline is somehow legally relevant. It's the employer that created that artificial deadline saying that if you don't accept the offer within a week, it's going to be revoked. The truth is that these severance packages are not being provided to you out of the goodness of the employer's heart. These severance packages are being provided because the employer has a legal obligation to pay you severance. So if the employer withdraws their severance proposal, doesn't mean that you've lost your entitlement to severance. In fact, it just means that you'll have to fight to get it back, or hire a lawyer to do that for you. But because your severance entitlements haven't disappeared, it's actually very, very rare for an employer to revoke a severance offer. All right. So what we always tell our clients, if they're trying to get in touch with a lawyer, are worried they're going to miss the deadline, you can always just reach out to your employer, ask for an extra week to review the offer. If you tell them it's because you want to have it reviewed by a lawyer, what are they going to say? No, we don't want you to have your legal entitlements reviewed by a lawyer. No, they won't say that. Instead, they'll say, yes, go ahead, take the extra week, get the advice you need, and then make a decision. And if you decide that you don't want to accept their severance offer, if you want to make a counter offer, then it's important to realize you're not beholden to their timelines. If you're not accepting your employer's offer, then you don't need to respond within a week that you're not accepting their offer. You have 2 years to sue them, so you have plenty of time to get your ducks in a row and ensure that you put your best foot forward when you decide to negotiate your severance. So keep that in mind next time you see, on a termination letter, if you don't get back to us within a week. I see sometimes it's 2 or 3 days, very, very short. And it puts an immense amount of pressure on people who don't know what their legal rights are. All right. But if you know what your legal rights are, if you come to the table knowing what your entitlements are, knowing what the law says about these timelines and deadlines, then you'll be in a better position to get the severance you're entitled to. What kind of severance are you entitled to? It's simple. You can simply visit our website, the Pocket Employment Lawyer. On that website, we have a severance pay calculator. This is a document or a tool that allows you to calculate how much severance you're likely entitled to. It looks at the 4 main factors that courts will look at in determining your severance entitlement, which are your age, your length of service, the kind of job that you had, and the availability of similar work. And it'll tell you in terms of months what you're likely entitled to. It's free of charge. You don't have to pay to use it. There's no obligation. We're not going to follow up with a call unless you want us to, unless you want to discuss your entitlements. You don't have to provide your email or your name or anything like that. It's just an information tool, because we think that if employees know what their rights are across the board, the likelihood that employees get a fair severance gets higher. We have a question coming in from Julia Creus. Julia asks, how would I calculate my earnings if I work as a counselor and my income is based on the number of clients I see in a month? I am employed by a larger firm. So there's a lot of people out there that have a set salary. They're paid every year, whatever it is, 50,000, 75,000. Whether they work 30 hours, whether they work 50 hours, that's what they're getting. Well, 50 hours, you still have to be paid overtime, even if you're on salary. But then we have other people like Julia who are in a bit different situation. Their salary, for whatever reason, will vary from month to month. In Julia's situation, um, it varies from month to month based on the amount of consults that she does. So if we're at the stage where we're, going after a certain amount of months of severance, say we want that severance to be, say, 7 months of severance, for instance. What is the amount of severance of income that we use for each and every month? So essentially, there's different ways of doing it, but essentially, all these ways try to answer the question: what is the likely income that Julia would have earned in the 7 months following her termination? So sometimes we'll use a 3-year average of her annual compensation. Sometimes we'll use the last year. Sometimes we'll use a 5-year average. It really depends on what answers the question best. What would Julia have earned over the next 7 months? All right. But generally, it's going to be based on your yearly income, especially if, month of February is a low month, but the month of September is a high month. There's kind of seasons in the year. Basically, that's accounted for when you look at the full year compensation. Of course, if you are terminated right at the start of your busy season and you have a relatively short period of notice, say a period of notice of about 4 or 5 months, and that happens to be the busy season, that you don't have to, use the months that were at the low end of your wages. You can say, well, yeah, this is what I earned over the last 3 months, but that's a slow season. This is what I usually earn in the busy season, and this is what I'm going to go for. So we're just trying to, get an understanding of what you would have earned over the period of severance that we're claiming. JBK asks, can I be approved for EI now since that all restrictions are being lifted and being vaccinated isn't mandatory? So the challenge we have with EI right now is that it's in EI's hands whether they decide to approve you or not for EI. So what we can do right now, employers are being directed by EI to use a certain code on the record of employment, and EI is investigating to see if that layoff, that termination, that leave of absence was related to a refusal to get the vaccine. Internally, EI is taking the position that if it's because you did not get vaccinated, then you're not entitled to EI. That, as far as I know, has not yet changed, even though restrictions are lifting right across the country. The best solution, in my view, is to contact your MP, your member of parliament. Let them know how dissatisfied you are with the way that EI is preventing you from getting any benefits, even though you've likely paid into it for years and years and years, and now that you need it, it's not available to you. So reach out to your MP, your member of parliament. We have a question from Judy on Facebook. I've been a contractor for the same company for 13 years. Recently, they asked us to stop using company email and create our own using their logos, etc. in our signatures. Is this because we are likely employees and they are trying to remove us from the company so we aren't classified as employees? That's likely, absolutely, the reason that you're being asked to show the world that you're not an employee of theirs. So that's one criteria that will be looked at when you're determining whether this person is an employee or a contractor, is how does the company present that person to the world, right? If you and the employer have an agreement that you're a contractor, but you're made to wear their uniform, you're made to give out their business card, you have to put their logo on your truck or on their emails, and no one outside of the company knows that you're a contractor, that's a pretty good indication that you're an employee. So I think that is probably why they're doing that. It is possible to have, you don't have to wait to be terminated to have your status reviewed. You can do that while you're employed as well. Either through the Canada Revenue Agency can determine whether you're a contractor or not, for instance. And if Canada Revenue Agency determines that you are an employee, then that'll make you eligible for EI and CPP and deductions at source instead of having to remit HST and then also taxes. So definitely something you can look into. I have another question coming in here from Speeches Beyond. I was wrongfully dismissed, but my employer tried to fire me for just cause. My case looks good for getting my severance. After I win, can I still sue a coworker for defamation who got me fired? So if you have if you have a wrongful dismissal action, actually, I wanted to talk about this as well. So I'll just touch on this very quickly. The likelihood that your matter goes all the way to trial is about less than 1%. What'll happen is likely in the process, it'll get settled. Now, a settlement is the employer providing you with an amount of severance, but they also get something in exchange. And what they get in exchange is you signing a document called a release. And what the release is, it releases the employer and a lot of the associate employees from any future lawsuits, all right, including any wrongful dismissal lawsuits. So it's just imagine you're buying a pack of gum. You pay all the money, that $2 for the gum. You get all the gum in exchange. So there's an exchange of consideration, exchange of value between that proposition. So in a settlement, there's also an exchange of value. You get paid your severance. You promise not to continue with your severance lawsuit, and generally any other lawsuit that could arise out of the termination of your lawsuit. So to answer your question, Speeches Beyond, yes, theoretically you could pursue that employee for defamation, but if you have to sign a release to get your severance, then you'll probably sign away your right to pursue that employee for defamation. We have another question coming in from Belinda Beguilin. Sorry if I mispronounced that. What sort of rights do seasonal workers have when it comes to being let go, not called back to regularly performing duties? I've worked at a few different jobs seasonally, and now I have nothing for the summer. That's a great question, because there's kind of two ways of looking at it. Imagine a scenario where you, for instance, and I had something like this in the past, you work in lawn care maintenance at a golf course. And of course, the golf course is open during the golf season and then closes at the end of the golf season for the winter. So when it closes for the winter, you're not entitled to severance when you get laid off, right? Because you're expected the next season you'll be called back. And so you do that for a certain amount of years, 5, 10 years. You're working in the lawn crew and you get laid off every winter and you get called back every summer. So for those winter months, when you're expecting that the golf course is going to be closed, you're not entitled to severance for those winter months. But now you've been working for 13 years, 15 years, whatever it is, and they decide not to call you back for the summer. Yes, you are entitled to severance in that case. Absolutely. When the summer season starts, you're entitled to severance because they didn't call you back. So yes, you are entitled to severance, but not at the end of the season or not at the end of the performance of the job, but because you never get called back again. All right, so absolutely. You do have rights to severance even though you're a seasonal worker. Absolutely. Now, an issue that I wanted to talk to you about today is resignation versus termination. Now, my colleague, Haley Rushford, was talking about this on a blog post on our website that you can read. We have a lot of blog posts dealing with a lot of the information that we also give here on the show. We also have a lot of information dedicated to dealing with common employment questions, COVID-related questions. All of that is on our blog show, and that's employmentlawyers.ca. That's employmentlawyers.ca. So feel free to visit the site. There's a wealth of information there for you to review and digest. Employment lawyers, sorry, not in the plural, in the singular. So what happens, what I'm seeing a lot is we'll have an employee who comes to see us because they've been placed on a leave of absence because they didn't get the vaccine. And there's a vaccine mandate in the workplace. And so after a certain period of time, the employer will say, you know, we told you you need to get the vaccine to continue to be employed here. You've told us you're not getting vaccinated. We're going to treat that as a resignation. All right. And they're going to say, you've resigned. All right. The reason they do that is because they want to terminate the employment relationship, but they don't want to pay severance. And so they say that you've resigned. And as everyone knows, when you do resign from a job, you're usually not entitled to severance because you're the one leaving. However, you have the opportunity to have the judge decide whether what happened to you was actually a resignation. And a resignation has to be clear and unequivocal. All right. So you can't be deemed to have resigned. All right. You actually have to resign either explicitly or impliedly. So explicitly is you tender a letter of resignation. Impliedly is, you're scheduled for work for the next week, and then the week after that, and the week after that, and you're completely missing in action. So that could be construed as job abandonment. But if you're not actually scheduled to work, if there's no work for you to perform, if you're not allowed on the work site, and if you're not being provided with pay in exchange for your work, then you haven't turned down any work. You haven't quit. You haven't abandoned your job or anything like that. In fact, what often ends up happening is that you've been constructively dismissed when you were placed on a leave of absence, when your hours were cut to zero or what have you, and you quit only thereafter. So that generally when you're constructively dismissed, you oppose the change to your working conditions. So for instance, you're placed on a leave of absence, you say, I'm not okay with being placed on a leave of absence. I'm going to treat this as a constructive dismissal. Oftentimes, traditionally, you had to quit when you claimed constructive dismissal. Not necessary anymore, but oftentimes that was required. And so the employee would quit, and the employer would say, well, we didn't do anything wrong here. And then the employee quit. So we don't owe that person anything. The fact is the constructive dismissal happened first. And so that you quit or not is actually quite irrelevant. All right. If there's a constructive dismissal, then you're owed severance. So my name is Lluc Cerda. For those of you joining in, we got a few more questions come in, and we're going to look at those right away. I'm the Senior Managing Associate of the Calgary office of Samfiru Tumarkin. I'm here to answer your employment questions. Feel free to put them in the chat, and I'll answer as many of them as I can. So we have a question from Joe on Facebook. Can I choose to continue wearing a mask at my work, or can my employer force me to not wear one? So I have not heard of any employer forbidding employees from wearing masks. Theoretically, I think an employer could refuse to allow you to wear a mask at work, but what happens in that case is that you can say, well, listen, I think it's important for my health that I wear a mask. So if you're refusing to allow me to do what I think is necessary for my health, then that's a constructive dismissal. I'm going to treat that as a constructive dismissal, and I'm going to go after severance. So it's important to realize is there's no way you can actually seize the courts to have a judge determine whether you're allowed to wear a mask or not. What you can do, though, is say, listen, judge, look at what this employer is doing, forcing me to not take care of my health. I'm concerned about my health. I quit my job because I don't want to work in an environment where I can't take care of my health and my safety. And now I'm going after my severance. The judge is not going to decide or force the employer to allow you back to work with your mask on. The judge is going to say, well, listen, you have to let this person wear a mask. If you don't, you owe that person severance. So now pay that person severance. That's what's going to happen. So the first thing you have to decide, Joe, is are you willing to lose your job over the fact that your employer won't let you wear a mask? And then if you are, then contact us. We'll help you determine whether that amounts to a constructive dismissal and how much severance you're owed. So to find out how much severance you're owed, you just simply visit our severance calculator, pocketemploymentlawyer.ca. You'll find our severance pay calculator there. It's anonymous, no strings attached. Put in your information. You'll get the amount of severance that you're likely owed. And then if you want to contact us to discuss moving forward with getting your severance, we'll be happy to speak with you. Belinda is following up with a question. What about having work impacted by something like a natural disaster, like wildfires? is there anything an employee can do if there are natural causes to the work interruption? So let's go back to my example of the golf course. So you work in the lawn care crew in the golf course for 13 years, and then you're about to go back to work there in the summer. The golf course gets burnt to the ground in a wildfire, for instance. So an employer could likely claim that that's going to be frustration of contract. What that means is that it's not that they don't want to employ you, it's not that you don't want to work, is that the golf course has disappeared, right? There's no work to be done on the golf course, it's disappeared. When that happens, generally the courts will say, well, both parties walk away without any exchange of anything. You don't have to provide your employer any notice of resignation, and the employer doesn't have to provide you severance, because it's no one's fault that this happened, this fire. However, if by the next season the employer has completely rebuilt the golf course and it's ready to go and there's work available and they're hiring everyone back, but they're not hiring you back, then that frustration has disappeared, right? I mean, they were able to rebuild. There's work now. They did it quickly, so that's not like a cataclysmic event that prevents them from re-employing you, in which case you're owed your severance. It's kind of a fine legal point. If this is more than a theoretical question, if this has happened to you, then definitely reach out to us, because we can help you determine whether you're owed severance or not. If you're not being called back to your job and you've been there for a while, even on a seasonal basis, reach out to us, give us a bit more of the facts, and we'll help you know whether you're entitled to severance or not. Absolutely. Jack Burton asks, can your employer force masks on employee in retail after March 21st when they don't require customers to wear one? How is this even possible? So I think by March 21st, you might be referring to Ontario, where the mask mandate is going to lift next week. My understanding is the mask mandates have lifted here in Alberta and in BC as of today. So unfortunately, an employer has a lot of flexibility. They can force you to wear anything. Like, for instance, they can force you to wear a work uniform, a cap with their logo on it, or even a mask. That said, the question becomes is, if the employer is allowed to do this, do I have to accept it? And if you decide that you don't want to accept it, then it's not to not wear the mask. It's to say, I've been constructively dismissed by the fact that I'm being forced to undergo these proceedings, these procedures, these changes to my working conditions because by the employer. So again, a judge is not going to decide, can the employer force you to wear a mask or not? Or can you go back to work with an order saying, you can't force me to wear a mask? A judge is going to decide, is the fact that you were forced to wear a mask a constructive dismissal? And if it was, how much severance you're. So the courts are not going to get involved in the nitty gritty of, whether you have to wear a mask or not like that until it becomes serious enough that it amounts to a termination or a constructive dismissal. And then what we're really talking about is your severance. All right. So there's just no way from a legal perspective to force the employer to change their policies other than by claiming your severance. Speech is beyond. So Speech is Beyond was asking earlier if he could go after his former colleague for defamation. So he's following up with, wow, thank you. I was bullied by a coworker for 6 years. I now have depression and health issues. I'm very sorry to hear that. I see that sometimes in the workplace, and it's really awful what some people are put through. So Speeches Beyond is asking, should I just go after defamation or a severance? Well, my question to you, Speeches Beyond, why don't you do both? You could theoretically go both after defamation and after severance at the same time. I don't see why you have to wait until your severance issue is resolved before you go after defamation. That's the way I would do it. If you want to go after both, and now that I realize that this has been quite a traumatic experience, you might be owed more than severance. You might be owed punitive damages, moral damages, aggravated damages especially. and damages for defamation. You're right, absolutely. So I wouldn't necessarily sit on the defamation component until you've dealt with the severance component. Instead, I would say you reach out to us, give us a bit more of the facts, and we'll let you know whether we can help you go after the defamation component as well as your severance. Absolutely. So JBK asks, can I sue for back pay if I'm called back to work for not being vaccinated? I think you can, absolutely. So essentially, when you're called back to work, the employer is saying, sure, you might have been entitled to 12 months of severance, but I'm calling you back to work after 3 months. All right. And you can say, well, that's fine. I'm ready to go back to work and start working again. But what about the back pay? Really, I've been without income for 3 months. I want to make it a condition of my return to work that you make me whole for this illegal leave of absence that you forced me on that was completely unjustified. Absolutely. And that's the approach we're taking. Sure, I mean, vaccine mandates are getting lifted. You know, the restriction exemption program is over and all of that. But there was never a vaccine mandate in the province of Alberta from the Alberta government forcing anyone to get vaccinated. So it was always the employer's decision to force their staff to get vaccinated. So that's a constructive dismissal in my view. And if they want to call you back now, if they've changed their mind, pay the back pay. Absolutely. Alib asks, can the employers allow vaccinated people to be working from home full time while putting unvaccinated people on paid leave and allowing them the same option? On unpaid leave. All right. So that's where it kind of stops making a lot of sense, these vaccine mandates. When everyone's working from home, that someone who's vaccinated can continue to work from home, never go into the office, never interact in person with a colleague or a client or a customer. But someone who's unvaccinated, who's also not interacting with anyone, has to be placed on a leave of absence. So the question Alib is asking, can the employer do that? So again, what I want to just emphasize here is not whether the employer can do that, but what do you want to do about it? All right. So Alib, in this case, it looks pretty clearly like a constructive dismissal, in which case you can go after your severance. If you're ready to go after your severance, then it's important you contact us, and we will help you go after your severance. Again, it's not possible to ask a judge to say, Alib's employer, you have to allow him to work from home even though he's unvaccinated. The judge, all they can do is say, well, that's a constructive dismissal, employer. Now you owe Alib a severance. All right. So a judge is not going to look at rewriting any policies or anything like that. All right. All they're looking at is, does this policy amount to a constructive dismissal? And if it does, then you're owed a severance package. But the first step is for you to decide, I'm willing to walk away from this job. I'm willing to go after my severance and pursue my entitlements. If on the other hand, you're like, I'll wait it out, maybe it'll change in 2-3 months or something like that, you might lose your right to go after your severance. All right. So it's important you make a decision. The decision is yours to make. We can't make it for you. You have to decide whether you're willing to walk away from the job and go after your severance. All right. Alib's got a follow-up question. Can an employer also refuse to pay out the bonus from previous years once the employee is put on unpaid leave to the COVID policy? So again, the employers can do anything they want until you decide to do something about it. If you do decide to pursue your severance, then your severance is based on your total compensation. So if you're owed 12 months of severance, then essentially you're owed 12 months of your full compensation, all right, which includes benefits, pensions, bonuses, car allowance, all of that. So your bonus would be owed as well. Yeah, absolutely. So they decided not to pay it. If you're willing to pursue your severance, we can get that bonus for you as well. Absolutely. So everyone, thanks for joining. My name is Lluc Cerda. I'm the Senior Managing Associate of our Calgary office here in Alberta. I've been answering your questions today on the employment law Q&A. We have a show every day of the week, so feel free to jump back in if I didn't get to your question today. One of my colleagues will be happy to answer that question for you tomorrow or thereafter over the coming weeks. Thanks once again for tuning in and for providing me with those very insightful questions. And